Plenty of times, a person will give me a call and explain the accident to me, and they have the feeling that the accident was partially their fault. And believe it or not, in New York State, that's okay. There's something called comparative fault or comparative negligence. In New York State, as long as you can prove that the other party, the defendant in a litigation, was negligent, had a duty of care, meaning a responsibility, and breached that duty of care that caused or was a substantial factor in causing the accident, you can establish the other party's negligence. Well, the next question is going to be, was the injured party, were you actually negligent also? And it's the same analysis. Did you have a responsibility? When you were driving the car, did you have a responsibility? Did you breach that responsibility, and did that contribute to the accident? And if it did, the only analysis will be what percentage of fault lies with the defendant or the other party, and what percentage of fault will lie with you. So you can bring a successful claim for injuries even if you are at fault. However, you must realize that any percentage of fault assigned to you, whether it be through negotiations or after a trial with a jury, will reduce your ability to collect your damages. So as a simple example, if your case was worth $100, if the other party was 100% at fault, you could collect $100. If your case is worth $100 and you are 50% at fault, then you'll only collect $50. So you can absolutely proceed forward with a case even if you were partially at fault for the accident, but it will eventually reduce your ability to collect the full amount of your damages.